Hi, I'm Dr. Shammick Kotecha from the Kotecha GPS Club. Continuing our talks about COVID-19 and dentists. Today, we're going to talk, now that we're going to go back to work, I'm joined by Stuart Rudner from Rudner Law, Employment, HR, and HR Law and Mediation. Thank you very much, Stuart, for joining us. We appreciate it.
Oh, thanks so much for inviting me. Looking forward to the conversation.
So today we're going to go through a bunch of topics that I feel are important for dentists in Canada and specifically in Ontario to deal with. Before we go any further, I'm going to talk about a disclosure. This is for discussion purposes only. If you need legal advice, please contact your lawyer to get the appropriate advice. Okay? I think Stuart agrees with me on that one. So
absolutely, and I'll be more specific. Contact an employment lawyer when you're talking about employment law issues.
I would take that. That is very important because not all lawyers can figure that out, or they have specialties, just like dentists have specialties.
Exactly.
So we're going to go through a whole bunch of topics today. We're going to start with CWS because it is something that many of us are going to be using going forward. If you're watching this video in the future, things may have changed. This was filmed on June 1st, and as of June 1st, this is what we knew at this point. So let's talk about CWS. It's been extended for us till August 29th of this year, and it requires you to lose 30% revenue compared to that same period last year, except for one period in March, which was 15%, correct on that?
There's actually two ways you can prove that you're entitled. One is to show a year-over-year comparison. So let's say April 2020 versus April 2019. Or you can also elect to compare it to earlier this year, so an average of January, February, which is helpful for people out there that have just started recently, or let's say their business was on an uptick, but now we've had COVID. So you can do it one of two ways, but either way, you're going to have to show a drop in revenue.
Okay, yeah, you just got to. I think I was told you got to use the same one for every period, correct?
You're right. You can't use it once for April and a different way for May, etc. It's got to be the same approach either way, but you can choose which approach you use.
Okay, so the things that I think that from a dentist point of view that I would like to talk about is when we talk about top-ups, the 25%. So most of us understand that it pays 75% up to $847 per week. So what I'd like to talk about is, there's been a lot of discussion amongst me and my colleagues on whether the 25% we have to pay, we should pay, we're legally obliged to pay. What is the legal opinion on that?
Yes, I'll tell you, we work with a lot of clients, a lot of dentists in particular. We have this discussion all the time over the last few weeks because, if you look at the law itself, it doesn't say you're required to top it up at all. Even, it doesn't comment on the extent or even if you have to do it at all. But the government was pretty clear in the messaging, saying they expect employers to make best efforts or reasonable efforts to top it up. So what we're telling all of our clients is, it's not a requirement. You're not going to be disentitled to the wage subsidy if you don't top up your employees. But at some point in the future, there may be questions. So you should document your analysis, your calculations, and if you can show that realistically you just could not afford to top it up, then just make sure that's in writing. And remember, it's not all or nothing, right? It's not either 0 or 25%. You could top up your employees by 5%. And if you can show that, look, that was just what was viable for your business, for your practice, then that should be acceptable. I think where you get into trouble is where you just by default say, oh, well, they're going to pay 75%. Great, but we're not going to top that up at all.
So,
sorry, go ahead.
No, go ahead. Finish your thought.
I was just going to say, as soon as they see that 0, they're going to wonder why, and they're going to expect you to justify it. And you may be able to, but make sure that you can.
Okay. So what I've seen up to this point, because it's June 1st, most of us have not been in the clinics, but most of us will be going back soon. Up till now, I've seen trying to keep, if you had any employees on payroll other than yourself or your family members, you were paying them to the maximum $847 and getting the full CWS back. Now, going forward, I'm going to talk about, I think most of us are going to have many more employees coming back. And so I think it's important that we go through somewhat of an example for people to see. So for this example purposes, I'm going to pick easy numbers because I don't want to do math right now. So
that's good. Lawyers are not good at math, so keep it simple.
So I got to say, if you have an employee making $40 an hour and they work 30 hours a week, that is $1,200 of gross pay. Now, obviously there's vacation pay and there's employer part of CPP and EI that you will have to make. So the question for me, so if you have someone who works 30 hours, I'm a big believer that you pay people for the work that they do. I don't think you can claw them back. If they actually were in the clinic for 30 hours, you would remit whatever the number was to them after taxes and that, but you would get back from CWS a total of $847 for that week. Is that correct?
Yeah, that's exactly right. You're not going to get more than 847 no matter how you slice it. And just to your point, I mean, I think it's fair to pay someone if they're working, but there are businesses that genuinely cannot afford to. And if that's the case, then you could pay them $1,000 instead of $1,200 or $900 instead of $1,200. Again, as long as you can justify that.
Yeah, I mean, so for me, what I did is I have two offices, and I had someone on payroll, the office managers, both at a reduced level, just outside of that number, just so that I could, because I had no revenue. Now that I'm working, I've increased their hours back because now I hope to have the revenue to pay for the difference in the 75 to 25%.
Yeah, and I think that's a big distinction, right? When you're closed, when there's no revenue, it's much easier to justify not topping up. Once you have revenue, it's going to be harder to justify that.
So the take-home message for you dentists listening is, now that we're working, you're going to have to start making up the difference. So important point. And then the last thing is, let's talk about with this topic is CWS with other programs. There's interactions with wage subsidy, work share, and they all affect how much you will get back. And some may have found this out after the fact because they've been filling out the paperwork on the My Business Account portals, and now it tells you what you get back. So, and I will say the government has been very quick in getting money into people's bank accounts. But let's just talk about that a little bit and how they kind of intermingle.
Yeah, sounds good.
So in terms of so they both detract from that, correct? So if you have someone on CWS, you have to remove work share. You had a formula that I saw that was pretty good.
Oh, yeah, I have to I'm going to share that sort of separately, and if you want to include it. But I mean, it's important to remember that, if you're getting the CWS, that doesn't count. It doesn't count. Or if you're getting the CRB, that's not wages or revenue. So that doesn't count. But it's also important to remember that the whole purpose of the CWS, the wage subsidy, is to get people off layoff or to avoid layoffs. So you can't have both. You can't have a staff member who's getting the CERB and the wage subsidy at the same time. And we've had a lot of clients who had staff who were on layoff getting CERB, and they brought them back, and they may not have been working, but they took them off layoff, and now they collect the wage subsidy. So they might be getting 75%. And then, as we were saying before, once things start moving and there's work and there's revenue, then you start to top it up and hopefully get them back to 100%.
Yeah. So along that lines, if you do make mistakes on CWS, what are the penalties? So let's go through that. So if you aren't eligible, what happens? And if it's deemed to be malicious or taking advantage of the situation, it's a different penalty, correct?
Yeah, I mean, if you just got it wrong, you made a mistake, they're just going to take the money back from you. But they've made it pretty clear. And there was some pretty tough talk from the government when they first announced the subsidy and as they were introducing it, to say that, their goal is to get the money flowing quickly, which meant they weren't going to be checking as closely as they otherwise would have. But at some point, they are going to be checking. And if they find that it was dishonest, then there are penalties of obviously paying the money you got, but a penalty of up to 25% of what you received in addition. So again, if it's a good faith thing, you're not going to be penalized. You're just going to have to repay the money back. But if it's not in good faith, then there will be penalties.
So yeah, it's which makes perfect sense. I mean, they're never going to give you money for free in this world, especially not from the government. And then the last thing that I don't know if a lot of dentists know that they can use this and how they use it, but if you have a staff member that is on CERB and cannot be recalled, and we'll go through some of those things later, you are allowed to have them work a small amount for up to a certain amount. That is correct?
Yeah, that was a change because initially it was zero. There had to be zero income at all. And obviously there was a lot of protests because some people are working partially, et cetera. So now you're allowed to up to $1,000. but otherwise, and in a period. And we're always looking at, in the CRB, it's month-long periods. So once you hit the $1,000 threshold, if you go over it, then eligibility will end. But otherwise, you can have them work and pay them up to $1,000.
Right. That's important to know, because you may have staff members that can't come back right now for whatever reason, but they are willing to come back for a little bit of time that could help you out, get your business going again. Which takes us to our, employees. We're talking a lot about employees. We're talking about, there's lots of confusion on different things. I'm going to turn the topic to constructive dismissals, contracts, different strategies, and new legislation that's not only in Ontario, but in other parts of the country. So I've heard lots of different talks on constructive dismissal. I've heard lots of different versions of it. What I'd love to have is just a definition that all dentists should know. What is defined for us is that we can be somewhat and I'm going to use the word liable, because that's important, is liable for putting someone in constructive dismissal.
Yeah, look, I mean, there's a lot of debate, a lot of discussion, and one of the challenges is, like a lot of laws, there are often no hard and fast rules. So you asked for a definition. Simple definition is a constructive dismissal is a unilateral and fundamental change to I'm going to start that one over. A unilateral and substantial change. So a unilateral and substantial change to a fundamental term of the employment relationship. So a couple of key words here, and I'll go through this. Unilateral, obviously, it means you're imposing it. So it's very different if the employee agrees, and we'll come back to that, but that's really important. Substantial change. So it's got to be significant. It can't be a cut and pay of 2%. And it's got to be to a fundamental term of the relationship. So things like compensation, hours of work, title, things like that. So you talked about constructive dismissal, and where this often comes up as layoffs. And I was very vocal very early in the whole pandemic in saying that we were reading about all these layoffs, and in dental industry was, one of the worst hit, because, I mean, you guys basically were all but shut down, if not shut down completely. So most people just sent everybody home on a layoff, and everyone assumed that they had the right to do that. And frankly, in most cases, they probably didn't have the right, because if getting back to the definition, what could be more substantial a change to the relationship than basically terminating the relationship on a temporary basis? Mm-hmm. If the very, very basic or very basis of the relationship is that your employee will work and you will pay them, and then you go to them and say, for the next, unforeseen period of time, you're not going to work and we're not going to pay you, that's a dramatic change to the employment relationship. So to me, that's a constructive dismissal. Similarly, if you say we're going to pay you only half of your previous wages or cut your hours in half, all of those things can be constructive dismissal unless you had the right to do it. And I know we've talked about this off air a few times. Contract is your best friend. If your contract says we have the right to lay you off on a temporary basis, then there's no risk of constructive dismissal because you had the right. Otherwise, what we did with a lot of our clients is we had them go to their staff and get them to agree to accept a temporary layoff in these very unique circumstances that we're in, because once they agree, it's no longer unilateral. And again, in that case, you avoid the risk.
Now, I'm going to say this from a dentist point of view. What if your staff says no? I mean, at this point, why would some of them could say no? I mean, most teams don't want to be out. I mean, let's be honest, most dental offices work as a team, at least in my opinion. There are some where they work as big corporations where they have intermoving parts, and that's a different relationship. But we're almost at the end of that 13-week period. Would you advise that had been done earlier, or can you still do it now?
Well, the whole 13-week period has changed. So let's park that and come back to it for a moment, because that's a big change in Ontario. But to get to your question of why would someone agree? We do work with employees as well, and we have a lot of people consult us. And in most cases, they realized that, this was not, a dentist who was looking to take advantage of them or abuse them or somehow deprive them of their income. This was an employer who was really stuck between a rock and a hard place, right? All of a sudden, the revenue was down to either 10% or 0% of what it was before. And yet they're being told they've got to keep paying their staff. It doesn't make sense. Something's got to give. And I've said that very publicly too, that the law of constructive dismissal really doesn't work in this circumstance that we're in now. And it may well change in the future when a court looks at it. But a lot of people looked at the situation they're in and said, I could fight a constructive dismissal battle now and I might win. but I've also lost my job, and who knows what is going to be available for employment in the future.
Mm.
So a lot of people are willing to accept basically a short-term loss
Yeah.
to protect their job going forward, especially if they knew that their employer was suffering too. It wasn't as though the employer was sort of gobbling up all the money and saying, we're putting you on layoff. If they knew that everyone was taking a hit, essentially, we had a lot of clients, dental and otherwise, who had staff that 100% signed off and agreed.
And you said, so the legislation has changed, correct?
Yeah, so this was late Friday afternoon. I think just to drive employment lawyers crazy over the weekend, they released this very quietly. So if you look on Twitter and you have any employment lawyers that you follow, you'll see some great debates about what this regulation is. Regulation 228/20 in Ontario. It doesn't even have a name. It's just 228/20. It was released, like I said, very quietly late on Friday. And it achieves a few things, but in the context of this discussion, what it did was that anyone who was laid off, anyone who had their hours reduced or eliminated altogether due to COVID-19, basically those layoffs have been deemed to be leaves of absence, which is a massive change because a lot of us were all worried that the 13-week period was rapidly approaching. So, and as I'm sure everyone knows, in Ontario, if you have somebody on temporary layoff for more than 13 weeks, it might be a deemed termination. Depends on some other factors, but it could be a deemed termination at that point, at which point you're on the hook for severance. So now that's not an issue because all of those layoffs have been overnight effectively converted into leaves of absence, which are not limited. The only twist there is what it means is that you have an obligation to reinstate them at the end of the leave. So I know a lot of our clients were thinking, well, maybe now's the time to kind of look through our workforce and get rid of people that weren't performing that well. Now, if it's a leave of absence, you actually have to bring them back whenever the leave ends.
I personally see that as the government protecting both employers and employees in one maneuver, because let's be honest, they don't want to see people lose their job, and they don't want to see businesses lose their businesses, because both of them can contribute a lot of tax to the system. So it is important. So along that lines, let's talk about contracts. I've heard you say that a couple times. And, in our off-air talks, we've talked about this a little bit, and I think it's important to talk about contracts. You said something during that last piece about severance. And in one of the things that you and I talked about, and in terms of a contract, how does a contract limit your severance? Because I think a lot of dentists need to know that, because, and if they get an employment lawyer to write these contracts for you, not your lease negotiator, not your corporate lawyer. Find someone who's specific in employer law. That would be advice, and that's dentist to dentist. So let's talk about this severance thing, because it's something we're going to have to deal with someday. How does a contract limit that for you?
Yeah, I've been saying this for probably close to 20 years now. The single best thing an employer can do is have contracts for all their employees. And the single most important part of that contract is probably the termination clause. So I'll try to make a long story not too long. But if you're going to let somebody go, and I'm talking about without cause, not because they were engaged in misconduct or what have you, you're going to let somebody go, you've got to give them either notice or severance. So you've got the employment standards legislation, which sets out the absolute minimum someone can get. And that's generally a week per year. And in most provinces, it's capped. In Ontario, for example, it's capped at 8 weeks. But then you've got the common law, which says everyone is entitled to reasonable notice. And there's a common myth out there that it's a month per year. What our courts have said is that they're not only going to look at length of service, that's obviously a key factor, but they'll also look at the person's age, the nature of their job, the availability of similar employment, and try to figure out how long it should take them to find new work. And the unofficial max for severance in Canada is 24 months, 2 years.
2 years.
So that can be what you're on the hook for, but you can have a contract which displaces that whole notion of reasonable notice and just sets out in black and white what the person will get. And as long as it's drafted properly, which is a big caveat,
yes,
as long as it doesn't breach the Employment Standards Act, which is another big caveat, and I'll tell you, I think you know this, there have been hundreds of cases in the last few years where people have challenged termination clauses. And courts will find any way they can to help individuals. But we can certainly draft one, and we have been drafting them, that will not be overturned, that will stand up. And to give you a sense of what this means, so as I said before, the unofficial max is 24 months. So imagine you've got a hygienist who's been with you for 20 years.
That's a lot of money.
She or he is in her 50s, and you're going to let them go. At common law, they're probably going to get at least 18 months of severance. Could be more. If you had a really well-worded contract, that could be as little as 8 weeks. So 18 months versus 8 weeks.
Wow, big difference. So my conclusion on all this is get good contracts. I mean, you're going to hear me say that a few times today, but I think, and we're going to go into a little bit later on about employee handbooks and contracts, how you update them, there's some things that you have to know. So we're going to talk about that. So that's great advice. I think it's awesome. So I'm going to transfer a little bit now. We talked about some of the not working part, CWS and constructive dismissal. Now that we actually have been told by our governing body that we can go back to work, we're going to talk about the issues that us dentists may face going back to work. So I'm going to start with, and as we're talking to an employment lawyer, we're going to talk about employees. So let's talk about the first thing I want to talk about is you send your recall notice. And if those of you who don't have one, there's some great resources. You can get them. I know the ODA has one on their website. I'm sure Stuart has some that he gives to his clients. I'm sure just reach out to your employment lawyer and recall your employees. So what happens if you send them this recall notice and they refuse to work? And the two reasons that I've seen talked about amongst the forums, amongst where dentists speak, is they don't feel safe, or you don't have the proper PPE or personal protective equipment. Let's go into that. What are your legal options as a dentist if you send the notice and then they don't want to come back?
Yeah, so this is the question we're getting a lot now. And it's kind of nice in a way because we spent 2 months talking about layoffs and wage cuts. Now we're talking about getting back to business, which is great. It's great for all of us. And I will say, we put together a guide to getting back to business. It's 30 pages long, believe it or not.
Wow.
We just finished it last week. And so if anybody wants a copy, they can feel free to email me or contact me. I'm happy to send them a copy. But it goes into this in a lot of detail and a lot more issues than we'll have time for today. But this is probably the most common question is, what do I do if my employee refuses to come back to work? And a point that I've been making a lot, and you would think this would go without saying, but in the COVID-19 world, it has to be said. Work is not an option. The same way, back in, pre-COVID days, if you can remember those, if somebody came to work on Monday and Tuesday, they couldn't just say on Wednesday, hey, I'm not going to work today. It's not an option.
No.
So the same thing now. If you were laid off, either officially laid off or unofficially laid off, you've now been directed to come back to work. You can't just say no. If you do, that's effectively abandoning your job. It's effectively a resignation. There's 3 exceptions to that. One is if there's a leave of absence that applies. So in most provinces, including Ontario, they enacted emergency leaves for COVID-19, whereas if someone cannot work due to COVID-19, they're entitled to a leave of absence. Keyword there being cannot, as opposed to prefer not. Yeah. Even if there's no official leave, every province, of course, has human rights legislation, and you have to accommodate for various grounds, such as childcare obligations or disability. If they have a medical condition that causes them to be more at risk than others, you may have to accommodate them. Accommodate them doesn't necessarily mean allowing them to stay off work. So let's say if they're an office worker or they're your receptionist, maybe they can work from home. And you can accommodate them by allowing them to work from home.
No, I mean, that gives you options.
It's not all or nothing. It's not, the employee doesn't get to decide their preferred way of being accommodated. You get to find a way that, as long as it's reasonable, you can choose one. I mean, I'll give you an example. It's not dental related, but a couple of years ago, I had a client who had an office and they had a worker who had been there for years. And all of a sudden she went to HR and said, I need to be accommodated. I have a hearing impairment. And this is the piece of equipment I want to allow me to do my job, which is basically answering phones. And so I got the call from my client who said, do we have to do this? And first of all, they weren't even convinced she had a hearing impairment. So I coached them through getting documentation to justify the fact that they had the need, and she did. But then they said, okay, this piece of equipment she wants is very expensive. Do we have to do that? I said, no, you can do your own research and figure out any other way that you can accommodate her reasonably, and then do that. And they did their research and they found another piece of equipment that was about 1/5 of the cost. And so that's what they put in place, and they were within their rights. So back to this situation, if the person can work from home, or we had one situation where just last week where an employee didn't want to take public transit during rush hour because they were worried because they suffered from, they were immunocompromised. But in consulting with their doctor felt they could take public transportation off peak hours. So the accommodation was simple. They adjusted her work hours.
Yeah.
So,
I mean, you gotta work with your team somewhat. I mean, they do work for you and they're part of your group. I think it's important to find that something where they feel safe and comfortable. I mean, you gotta be have a limit, but
yes.
you should be somewhat, especially during this time, because everyone's been through the ringer for the last 12 weeks. I mean, no one really doesn't want to work. So, I mean, that answers my question on that. Now, in terms
Actually,
of,
sorry, I'll cut you off for 1 second. I didn't get to the third exception, which will probably, I think, lead us into the next question. So as I said, first exception is leave of absence. Second is accommodation under human rights. Third is the right to refuse unsafe work. And I know you mentioned this as you're introducing it, but that is an exception if there's a legitimate risk. So I know we want to talk about that. So why don't we segue into that if that works for you?
Yeah, let's talk about that. So a big question over the weekend is we got new guidelines from our college, which don't match up with our hygienist's college. And a lot of the questions are, who makes, okay, I'm going to just do it in a scenario sense because it makes it easier. I own a dental practice. I get told that I don't need protective PPE equipment X. And one of my employees who's governed by a different college has a mandate saying they should have this PPE now. And I mean, I think most of us who are listening to this can pretty much tell you it's about N95 masks.
Right.
The question I have is who makes the final decision? So I follow my college. He or she follows their college. She complains to firstly, if she doesn't feel safe because it's not meeting her college's guidelines, what happens then? She makes a complaint to her own college or goes to somewhere else?
Yeah, so I think it's important to understand that I'm not talking about professional requirements, and you've got your own college to answer to on that front. But as far as the workplace goes, we have occupational health and safety legislation, which basically says that every employer has a duty to take all reasonable steps to provide a safe workplace. That's your obligation as an employer, all reasonable steps. So the question, of course, becomes what's reasonable? And it's very easy for us, employment lawyers like myself, to say in theory, well, follow the guidelines that you're being given by the government, by medical authorities, by your regulator, by your college. Those may be reasonable, but you've raised in a very interesting situation, whereas different regulators, different colleges are giving different advice. It's important to remember those are guidelines. That's advice. That's not law. And to your question about what happens if you can't agree, is the employee would go to the Ministry of Labor. And I've seen this play out dozens of times over my career, and it's played out a number of times recently. What happens is that the employee would go to the employer and say, I don't think that the workplace is safe. Then it's up to the employer to assess if there is a concern or not. But if they assess it and it's failed, I think it's fine. If the employee is still not satisfied, they go to their Ministry of Labor, and the Ministry of Labor will assign an inspector. And I can tell you in Ontario, they have transferred a lot of inspectors into this department. They've actually reached out to retired inspectors to help out because they know there's going to be a massive claims. But it goes to an inspector for the Ministry of Labor who will reach a determination as to whether the workplace is safe or not. And they'll probably consider the guidelines provided by the different colleges. But at the end of the day, they get to make their own decision as to what is safe and what is not. And if it's unsafe, then of course your employee doesn't have to return to work. But if it is deemed to be safe, then they do.
That's fun stuff for us dentists. So in terms of bringing them back, what you have the option to bring them back at different hours, correct or incorrect?
I'll give you a typical lawyer's answer if it depends. And we'll get back to your point earlier about having a good contract. So I mean, it gets back to constructive dismissal as well. So as I said before, a constructive dismissal is a substantial change to a fundamental term. So if someone previously worked, I'll say noon to 8 p.m. every day, and now you want them to work, 6 to 2 p.m., that's a pretty significant change. I think most people would agree that's substantial. So you may not be able to impose that unless you had a good contract, which said you had the right to change their hours to meet your needs or whatever else, or unless they agree. If it's going to be more of a nominal change, not to the level of substantial, then you can make those changes without a risk.
Yeah. So make sure you have good contracts. the question that has also come up, what happens if one of your staff members tests positive for COVID-19 or has any symptoms that are on our list of triage symptoms for our patients? What happens then, employee legally wise?
Yeah, I mean, this is a great question. I mean, it gets back to the point I made earlier about that duty to provide a safe workplace and taking all reasonable steps. So you're certainly not going to want that person in the workplace if they've tested positive, or even if you think there's a risk there. So first point is you want to have a really good health and safety policy in place. And I know we've talked a lot about contracts. The other main pillar of the employment relationship is policies. So we typically work with our clients to have really strong policies and really strong contracts in place. And what we're doing now with a lot of our clients is very specific health and safety policies for COVID-19, including a duty to report any symptoms or obviously any positive tests. So you're going to want to make sure you have a very clear policy that everyone knows about the policy, knows they have to report these things. Okay. And if they do, then, I mean, as I said before, you're not going to keep them in the workplace, clearly. If they test positive, they are legally required, of course, to self-isolate. But if it's just a matter of exhibiting symptoms, and I don't mean to minimize that by saying just, but if they haven't tested positive, you're still going to send them home. Yeah. The only difference will be at that point, because you're not allowing them to work when they were able to work, you're going to have to pay them for that. Whereas,
that's the question I'm going to get to, because that's the first question every dentist is going to ask. If they test positive for it, who pays them for the 2-week quarantine?
And here's where the law gets very strange, because if they test positive, of course, they are unable to work, which falls within the leave of absence under the Act, so you don't have to pay them. So you're actually in a worse position in that sense. So if they test positive, and again, this is all subject to negotiation, and you can be generous and you can pay them, even though you don't have to. But if they're unable to work because they've been ordered essentially to self-isolate, then you don't have to pay them. Whereas if you're telling them, we don't want you in the workplace, then you're going to have to pay them.
Yeah. So if you get an official test positive, then they probably go on one of the government programs, and if they do test, they just have symptoms, you probably going to have to pay them. So you're going to probably have to ask them to get tested. Right?
Yeah, it's a weird situation. I know a lot of our clients have not bothered to go down that road. Some have just paid anyways. Some have done a reduced level and relied on the wage subsidy if they were entitled to it. So it's a tricky situation, but the bottom line is you don't want them in the workplace.
Yeah, oh, yeah, that's definitely for sure. So, we've talked about this, and this has come up a lot during our talk today, but employee handbooks with policies and contracts. So if you have them already, what changes would you advise a dentist to do to both of them? And how often do you normally tell them to do this? Because, I'm going to talk about me. I've had both employee handbooks and contracts since the day I built one of my practices. Have I updated them that often? No. And now I'm thinking, well, maybe I should. So those are the questions I have.
Right.
So
yeah, no, I think it's a great question, and you're ahead of the curve, right? I mean, most of the businesses we deal with, most of the dentists we deal with, don't have good contracts, don't have good policies, if they have any at all. So as far as contracts go, I mean, I'll take a step back. We work with our clients to do what we always call an HR checkup, which is to review their contracts, review their policies, make sure everything is in good shape. And when I say in good shape, it's not just complying with the law. That's kind of, to me, that's the basic level. You want to be as strategic as you can. And I think the reality is, I think everyone probably knows this on this watching this video, employment laws are designed to protect employees. Yeah. And there are some things you cannot change, but there's a lot you can. And that's where the contracts and the policies come into place. So, I mean, we review our contracts several times a year. We tell our clients, basically, we'll develop a really good template. You can use that. But then, if 6 months go by and you're going to hire someone, before you do, let us take a look, because the laws may have changed, best practices may have changed. As far as policies go, you don't have to revise them or review them all the time. But I'd say at least, once a year, think about if anything has changed. Has your situation changed? Have the laws changed? You don't need a wholesale revision every year, but at least a review. And what we're telling our clients now, we're telling them two things. First of all, if you've been thinking about doing an HR checkup and now you're quiet, now's a great time to do it. You've got some time on your hands. You may have an office manager who's not doing a whole lot. Now's a great opportunity. But also let's, try to learn from this whole experience. So what didn't work? Back in March, when you had to shut down so quickly, did you have contracts and policies that made this easier, or did you not have them, or do you have ones that really didn't work? So as far as the contract, temporary layoff clause, we talked about that. Make sure you have one. Mm-hmm. Termination clause, we talked about that. Make sure you have a really good one. As far as policies go, health and safety should be updated to reflect what we've gone through in the last 13 weeks. Yep. Remote work, if you have people who've been working from home, make sure you have a good remote work policy. Sick days, what does your sick leave policy say? And is it consistent with what you want to be in a situation like this? Also attendance and absenteeism to deal with the situation we talked about refusing to work. And discipline. These are all things that you can put in place. And then on the contract front, I mean, like I said before, you can improve your rates dramatically. So flexibility, termination clause we talked about, but also just, simple things like vacations, sick days, duties, hours of work. You asked me this before, can we change their hours of work? You definitely can if your contract says that you have the right to change them. So look at all these things, and
I've heard you say this. I've heard other employee lawyers say this as well. Is even if you don't have a written contract, every employee has a contract, and it just becomes more ambiguous when there's nothing in writing, as it's a perfect interpretation. Well, if you have it written down, you have a much better chance of proving your own case. I've heard you say something along that lines before.
Yeah, no, I think we work together well. It's a perfect segue to what I was about to say, which is, one point is having a good contract. Every employee in Canada has one. Most of them are verbal, like you said. And if it's verbal, it's comprised of three things. It's comprised of whatever you actually discussed, which typically would be things like compensation and title and duties. Mm-hmm. It's also comprised of things that are implied by law, like that duty to give reasonable notice of termination I talked about. And it's comprised of your practice. Whatever the practice is ongoing becomes part of the contract. But you're right, it becomes ambiguous. And it's a whole lot, all those things that are implied are not for the benefit of the employer. So you can make it much stronger. But what I see a lot of is people have good contracts that are implemented really badly. And when I say that, the worst thing people do is you have somebody sign the contract when they show up for the first day of work. Because at that point, they already had a verbal agreement. They didn't just sort of randomly show up at your office. They showed up because you hired them. They already had a verbal agreement. So when you hire them, make sure they sign off and make sure it's clear they are not hired until they sign off, and then you're going to be in much better shape.
I think that's something that I don't think a lot of dentists deal with. They often say just sign the contract when you come to work, even if they do that. So it should be offer contingent on contract signature. Important to know. Very, very important. I don't have a lot of other topics to discuss. I think that you were really good at helping us from the practical point that us dentists need. That's kind of my mindset is trying to get the practical part out as opposed to some of the theory. So if we skipped over things quickly, I would advise you to go speak to an employment lawyer, or contact Stuart Rudner at Rudner Law. I will have his contact information at the end of this video. You're welcome to, if it's, just talk to someone, right? Don't make, and in conclusion, I've heard you say this in writing. You've written to some email is know your risks and learn from and prevent it before it happens, because if you're trying to react, it's always harder, correct?
So it's harder and always costs you more to fix a problem than it does to prevent it. So yeah, I agree. And the last thing I'll say is, I'll say a few things. First of all, we do have a running blog on COVID-19 workplace issues. So check out our website. It's rudnerlaw.ca.
Perfect.
But to your point, which I can only echo wholeheartedly, if you think you have an issue, if you're not sure your rights, your obligations, feel free to reach out. And if we can help you, that's great. If we can't, there's no harm done. But like you said, it's always going to cost you more to fix a problem later than it will to prevent it. So feel free to reach out, and hopefully we can help you avoid the problems.
That is perfect. Anyway, I want to thank you for the Kotecha GPS Study Club to helping us get some information out and during this time. And we're going to probably call on you again for some other things. So thank you very much. We appreciate it.
That was fun. So feel free to reach out anytime.
And once again, you'll get his contact information. You can reach out to me if you want, but I'm going to refer you right to him. So that's what I would do. Anyways, thank you very much.